Thank you for joining us for another Hagley History Hangout. My name is Gregory Hargreaves, Assistant Director of the Center for the History of Business, Technology, and Society at the Hagley Museum and Library in Wilmington, Delaware. Now, as you know, during these history hangouts, we like to bring you some of the terrific work being done by folks who have used the historical collections held in the Hagley Library, especially scholars who have received support from the Hagley Center in the form of research grants and fellowships of different kinds. One such scholar joins me today. Joël Praz is a PhD student at the Swiss Federal Technology Institute of Lausanne. Joël, thanks for speaking with me today.
Hello, thanks for having me.
Oh, you're welcome. Let's start by painting with broad strokes, so to speak. What is it you are researching and writing about?
So, my research takes place in a larger project about the history of the international patent system, if you want, that is led by Professor Jérôme Baudry at the Swiss Technological Institute in Lausanne. And we are studying from the middle of the 19th century to mid 20th century, the different ways of harmonization and unification of the different patent systems. As you know, or may not know, I don't know, in the middle and the end of the 19th century, the main economical power that were the USA, Great Britain, France, and Germany had very different patent systems. And in the 1870s and then in 1883, there was an international union that was signed, a convention that was signed that gave birth to the Union of Paris, which is the Union for the Protection of Industrial Property that aimed to harmonize a little bit, at least, the different laws in order for the companies, we could call them multinational companies, to be able to engage in business with the same pattern in different countries, because that would be prior to this convention sometimes impossible or at least very complicated. And in my PhD research, I am studying this union, which is part of which I define as the international patent systems from 1883 to just after the Second World War in 1950, and focusing on these four countries, so Germany, France, Great Britain, and the USA. So what I am looking at is not only this union, but also a few other organizations that were active around this union and to try and how would you say that to try and shape this union with different ideologies and of course different interests.
Well, what were some of the key objectives of that union?
Well, there are three different articles in the convention that are very important for patents. The first article is the second article of the convention, which says that each country has to manage the citizens of the other member states as its own citizens. So there is no discrimination with foreigners. They have the same rights to apply for a patent and get a patent in their country. That's the first very important one, but this is important also for trademarks, designs, and so on. Then there is the fourth article of the convention, which gives the citizens what we call a right of priority. And this is to avoid well, let me say this way. Prior to this convention, if you would get a patent in Germany, the patent office would publish your patent actually with the different information, because the deal when you get a patent is that the state gets the knowledge, the information to allow to diffuse it so that your competitors and other interested companies or individuals have access to that knowledge. So when the patent office gives the right to the patent, it also publishes the patent. And in other countries, that would be considered as that the 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 information regarding the patent is made public. And in some countries, if it is considered that the information of the patent is public, you can't get a patent anymore. So if the patent was published in Germany, France could say, oh, but it was already published. It's common knowledge. It's not specific. It's not technical. So we won't grant you the patent. So this right of priority gives you at the beginning, it is a period of 6 months. And then from 1900, it is extended to 1 year. It gives you this period to be able to apply for a patent in another country without risking being without the risk of being faced with the argument of the publicity of the patent, if you want. And the the, the third important article is the Article 5 of the Convention, which says, and that is the very how do you say, ambiguous article that would lead to a lot of discussion and a lot of disputes over the years in the convention and also in each national state about how it depends from the state if it is the patent office of the or the judicial system has to apply this article. But what it says that the patent must be worked in a country. So if you get a patent in a country, you must use it. But the problem is that then there is, because of France actually, there is a small line at the end that says, according to the laws of the country. So, which means obviously you understand that each country has its own definition of working a patent. And of course, if you get a patent of that for a product that is very complicated to produce, it is impossible to have it worked in all the countries of the Union. So this article will be discussed and discussed all over again. At first, it is the compulsory working of the patent that is asked. And throughout the years, with a lot of engagement also from the patent lawyers, it will be changed to that because sorry the if you don't work your patent, you risk losing your patent. And they want to change that and to exchange it with the compulsory licensing of a patent, which means if you don't work your patent, the only risk you have is that we will impose you a license. And only after that, if it is proven that you did everything that you could to avoid giving away a license, then only could the state cancel your patent. But from my knowledge, that basically almost never happened. The worst case scenario was to have a license asked of your patent. That is not taking into account the two world wars,
Mm.
because then everything changes.
Mhm. So, what was it that put Hagley on your radar as an important source for this work?
Yes, so the first and the major archive I use is the one from the World Intellectual Property Organization, because this union was managed by an international office. It was an international administrative public union, and this office was in Switzerland. And WIPO today has its siege in Switzerland, so it's the daughter organization, if you will. And I had the luxury to have access to their archives, so that was wonderful. And when I started this project, because in my master studies I studied two patent, but in Switzerland and a bit later, and it was filled with economical interest. We had pharmaceutical companies searching to protect their patent, of course, the longer, the stronger protection they could get. And it was always about economical interest. So when I started this project, I thought that in the archives of this international office, I would have a lot of correspondence or reports, talks with economical companies, private companies like Dupont-Nemours, for example, or IG Farben in Germany, and so on. And actually, I didn't find that. I found most people or companies corresponding with the international office or being active prior to revision conferences and so on, trying to deal with patent laws in the States. It's mostly lawyers or patent agents. And I was surprised. And I thought, so well, that's surprising. And uh, where the goal going to Hagley, and I did that in the three other countries, was to search through private companies' records to try and find to what extent they would talk about the Union of Paris. Because you're thinking, oh, patents, it's very important for the economy. Today we talk about COVID, we think patents are tremendously important, which is right. But at that point, we see that the International Union was not directly in contact with private companies, and I thought that that was surprising. So what I did was to try and find a few different companies that would go to the huge, like what would call today a multinational, so large transnational corporations, to a bit smaller companies that would have maybe some interest in international patenting, but that would have most of their business in one country, and to try and see uh, to what degree I would have to go to find mention of the International Union of Paris, actually. To try and see the limit, the frontier of this international patent system. Because now that I did my four countries, I can say that I have to go through the records of very, very large corporations that would have a major interest in patenting. That would mean basically Germany and the chemical industry to have a direct link between the Union of Paris and the patenting the patent office of the company, if you will. Yeah. So that's why I came to Hagley.
Sure, because of course Hagley is a premier depository for American business records of different kinds. And what was it that you looked at once you came to Hagley? You mentioned DuPont already.
Yeah, exactly. So I searched through the National Association of Manufacturers records, also the collection of the Chamber of Commerce of the United States, EI Dupont de Nemours, and then the National Industrial Conference Board. Those were the different records I went through during the week I stayed at Hagley. The wonderful week I stayed at Hagley.
Well, did anything really stand out? Was there any set of documents that you discovered and thought, oh, wow, this is really useful for me?
Well, sadly, no. I was very disappointed. Well, I was not disappointed because the only place I found the company with records mentioning and dealing directly with the international union was, as I mentioned, Germany, because with the chemical company and the chemical interest. But in Hagley, it was the same in France and Great Britain. It confirmed what I expected. It's that the and so the USA is a bit of a special case in the international union because it has a more liberal system, and the if you want the international union is a bit behind what the USA already does, because the USA, for example, has no compulsory working of patents. So they are fighting all the time to get rid of the compulsory working of patents and so on. So, and also, at least until the 1925 or 1930s, they have less interest in the international union. And so I was not expecting to find a very large amount of archives regarding patents. Well, there is some, but it deals with mostly national patent law reforms and so on. So not with the international union. I guess it passes through other channels and more sporadically because yeah, the USA is a bit less interested in this union at first. And then that is something very interesting and important maybe for later research. But and it was the same with other countries, but in the USA it was very we could see it very well that after the Second World War it changes a lot and abruptly, and I could see in the archives the folders adding up for after the Second World War with also mentioned of the international union. So I found the same in every country. So it's a bit somewhat disappointing for me because I stopped when I can see that on the international level, the every company basically is starting to organize really a department that is dealing only with patents and not only the large corporation. Everyone is starting to organize around that. So that would be maybe for a next visit.
Sure. Well, I suppose sort of a negative result, as it were, an absence in the archive can be revealing as well. So perhaps how do you interpret that? What does it tell you in terms of the takeaways of your project that the Paris Patent Union was not taken seriously or engaged in as actively prior to the Second World War as perhaps possible?
Mhm. Well, I think the Union of Paris is a very interesting case to see how the international life, the international organization develop throughout the time, especially with the patent case. That is somewhat a special technology. If you talk about patent as a technology, it is a legal one, an economical one, a technical one, and it is very important for so many different actors. And also throughout the period I studied from the 1870s to after the Second World War, a lot of things changes. So we could see a lot of things unfolding throughout the period. But as we see, we have to wait quite a long time to see uh, most of the corporation or not so large corporation dealing with this international union. And when I mentioned that I could not find correspondence or direct intervention of large companies in the international union, what I found, on the contrary, is the presence and almost all the time and always of lawyers that are engaging in this union also for ideological reasons because they believe that patents are good for society. They also have a private interest, of course, or personal interest to do so. But there is also this kind of development of the international relation at the end of the 19th century, also with the development of international right, of international law, sorry. And also this idea that international relation must be organized through international law as a science, if you want. And this union is really a very excellent case to study that because I can see these lawyers all the time, and I felt there are only lawyers actually, and that was also one of the goal to go in the archives of private companies in different countries, is to see are these lawyers taken seriously. And when you don't talk about them or not that much, maybe they are not so important. And also, it is something that is hard yet to measure. I mentioned that at the start of this talk that I'm doing this PhD in a larger project. And the other part of the project with Professor Jérôme Baudry and Dr. Nicolas Chachereau, they gathered the patents from also the 1870s to after the Second World War for the four countries I mentioned to do a quantitative research about the evolution of patents and also to try to see the link of the transnationalization of patents, if you want. So which taken was taken in which country and then in which other countries. Because I don't have those facts, we don't have those numbers. And I only have a few taken from the archives that it's impossible for me to check if it's true or not. But most of the time, uh, apart from the really huge corporations that can organize themselves on a transnational level, um, probably most of the patents, and by a huge amount, like 80% maybe, were not taken in other countries. And if they were also taken in other countries, just the neighboring countries and maybe the USA, if we talk about Europe, to because many states would not have the ability to produce these patents maybe. So it's something we must. I still can't give you a hard answer, but I think that the international Union was not um, serving so many people and so many company. Also, what I should mention is that it was, as I said, an international union, an administrative union, and that to change the convention, you had to have the unanimity of the member states voting for the revision. So it is incredibly easy to block a revision. So, and then each country would have to ratify the new convention. So that's so many steps that you can just delay or just block the revision of the conference. And I think that's also a reason why I can find in the even medium or quite large corporation a lot of interest in this union. It's because it's easier to get a hold of your own government and its delegation that will block it or not, the revision, than to deal directly, sorry, with the international level and the international conferences. Even though if we see after the First World War, the development of the International Chamber of Commerce, a quite important private international organization that will have then official delegates to the conferences. So the manufacturing and trading interest will be represented directly to the conferences. But that's also because the conferences, the revision conferences that takes place throughout the period, would often face sometimes danger, and most of the time so many different situations where it's basically stuck, and they are trying to get as much possible uh, as interest represented to be able to avoid such situation.
Hmm. Well, Joel, thank you so much for sharing your project with us. It sounds really interesting, and I look forward to reading it when you're all finished.
Thank you very much.
You're welcome. And for the audience, if you would like more Hagley History Hangouts, more information on the Center for the History of Business, Technology, and Society, join us online. You can visit hagley.org. That's HAGLEY.org. Don't be a stranger.